And the Senate has before it 3 amendments to bring accountability to this legislation: the Dodd-Feingold-Leahy Amendment, the Specter Amendment, and the Bingaman Alternative. I intend to vote in favor of each of these 3 amendments. I noted yesterday at the outset of this debate, and consistently throughout the course of Senate consideration of these matters, that I oppose legislation that does not provide accountability for the 6 years of illegal, warrantless wiretapping initiated and approved by the Bush-Cheney administration. The bill, if it's adopted without amendment, seems intended to result in the dismissal of ongoing cases against the telecommunication carriers that participated in the warrantless wiretapping program without allowing a court ever to review whether the program itself was legal. None of us are out to punish telecommunications, but we worry if anybody's going to be held accountable. As it is now, the bill would have the effect of ensuring that this administration is never called to answer for its actions, never held accountable in a court of law. I do not support a result that says the President of the United States, whoever he is above the law, and therefore I don't support the bill unless it is amended. It's now almost 7 years since this President began efforts to circumvent the law. In violation of the provisions of the governing statute, the Foreign Intelligence Surveillance Act, this President and his administration engaged in a program of warrantless wiretapping. I have said I believe that conduct was illegal. In running its program of warrantless surveillance, the administration relied on ends-oriented legal opinions, prepared in secret, shown only to a tiny group of like-minded officials. Basically, the administration said, this is what we want for legal advice, now give it to us. This is what we want to do to step outside the law, now you go tell us we can do that. As chairman of the Senate Judiciary Committee, of course I oppose that. And a former head of the Justice Department's Office of Legal Counsel described this program as a legal mess. And this administration wants to make sure that no court ever reviews that legal mess. The bill before us seems to guarantee they get their wish. So what if Americans' rights were violated? So what if laws were violated? This bill makes our federal courts the handmaiden to a cover-up. And that, Mr. President, is wrong. Make no mistake, if Title II becomes law, we would take away the only avenue for Americans to seek redress for harms to their privacy and their liberties. And there will likely be no judicial review of this administration's illegal actions. Those who claim that American citizens can still pursue their privacy claims against the government, well, they know that sovereign immunity is a roadblock and stops that. They know that cases against the government have been dismissed for lack of standing. They know about the government's ability to assert the state secrets doctrine. They know the Michigan case that held the president's warrantless wiretapping program illegal was later vacated for lack of standing. Indeed, for all the talk about holding the government accountable, they've chosen to do nothing to make any case against the government more viable. Red herring, if ever there was one. We're telling Americans we're closing the door on you. We're telling Americans, law-abiding, honest, good, hard-working Americans, that we're closing the courthouse door in your face because we have to protect the president and those around him who may have done something illegal. You know, if you support retroactive immunity of the telecommunication carriers without providing an effective avenue to challenge a program or obtain judicial review of its legality, that supports unaccountability, pure and simple. I would have supported the efforts of the government to indemnify the telecommunication carriers if we could substitute the government and have accountability. I also supported alternative efforts by Senator Specter and Senator Whitehouse to substitute the government in those cases. That would have allowed judicial review. The Senate's going to vote on a bill today which does not allow that. Mr. President, all the years I was growing up in Vermont, we were told nobody is above the law. All my time in law school, we were told nobody is above the law. We take an oath of office when we're sworn into this body. There's only 100 of us to represent 300 million Americans, but we're also told no one's above the law. We're about to vote on a bill that says, well, the president and those people around him are above it. In this democracy of co-equal branches, which not even the president's above the law, judicial review is an important mechanism to correct overreaching of the executive. Since the landmark case of Marbury versus Madison, the principle of judicial review has been firmly established. Fortunately, that principle is being sacrificed to this administration's claim that it, outside of all other administrations in this nation's history, this administration, the Bush-Cheney administration, should be able to act with absolute impunity and act outside the law. Now, I believe a federal court could well find that the limitations this bill, if enacted, would place on the court's ability to rule on the legality of this program are themselves unconstitutional. The court might reason that Congress could not have intended for the court to abdicate its judicial review role and become a mere rubber stamp. You know, court might nevertheless engage in meaningful judicial review. Wouldn't that be great? And they might reason to assure itself that the Attorney General's certification is valid and worth affirming as a justification for closing the courthouse doors to Americans claiming deprivation of their constitutionally guaranteed rights. A court might look at that and say you can't do that. One federal district court in Detroit has already declared the president's warrantless wiretapping program to be unconstitutional. Another in California just last week cast grave doubts on the legality of the president's warrantless wiretapping program, finding that the exclusivity provision in FISA left no doubt that operating outside the statute's framework, as the White House did, was unlawful. I want the courts to exercise their rightful role to ensure that justice is done. Federal judges and inspectors general perform different functions. Inspectors general are not well suited to determine whether the president's warrantless wiretapping program was legal. In fact, this bill prevents them from engaging in that kind of legal review. If the administration gets its wish to passage of this bill, there will likely be no conclusive judgment on the lawfulness of the president's program. No conclusive judgment ever, 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 and thus no accountability. So I don't support this legislation unless it's amended. I do not believe Congress should seek to take away the only viable avenue for Americans. Remember, we're here to stand in the shoes of 300 million Americans. Take away the only viable avenue for Americans to seek redress for harms to their privacy, but also the only viable avenue of accountability for lawlessness on the part of the administration. We should be stating what every American knows, that nobody is above the law. Senators aren't above the law, but a president is not above the law. And the administration violated FISA by conducting warrantless surveillance for more than 5 years. And then they got caught. They got caught. And the apparent purpose of this bill is to ensure now that they've been caught, they're not going to be held to account. That's wrong. So I'll vote to support the amendments before us today to bring accountability to this legislation. And I'll vote no in opposition to the effort to secure immunity for this administration's illegal activity. Mr. President, I ask consent that my full statement be made part of the record.
Without objection.
Mr. President, do I have time left?
30 seconds.
I'll reserve the balance of my time.
Mr. President.
The senator from Pennsylvania.
Mr. President, I have sought recognition to make the final argument in support of my amendment pending on a very vital issue facing this body. We are asked today to do two things which I believe are unprecedented in the history of the United States Senate. First, we are called upon to vote on legislation where most of the members admittedly don't know what we are voting on. And secondly, we are stripping the federal court of jurisdiction on some 40 cases which have been pending for more than 3 years and are in the process of litigation. On point two, we are flying in the face of the most fundamental decision in the history of the United States on constitutional law, Marbury versus Madison, going back to 1803, 205 years, Chief Justice Marshall saying that it is emphatically the province and duty of the Judicial Department to say what the law is. But the Congress is now being asked by the administration to grant retroactive immunity to the telephone companies, where the judge who is presiding on the case, Chief Justice Vaughn Walker, in the federal court in San Francisco, has declared that the terrorist surveillance program put into effect by the president violates the Constitution, exceeds his constitutional authority in directly violating the statutory provision that the exclusive way to wiretap is with court approval. Here we have a situation where it is admitted that most members of the House of Representatives, according to House leadership, have not been briefed on the program. What we have are allegations in the legal papers as to having the telephone companies act at the request of the government to invade privacy without going through the customary judicial process of securing a warrant. And on the floor yesterday, after extended argument, it's plain that most members of the United States Senate have not been briefed on this program. There's an old expression, buying a pig in a poke. It means buying something that you don't know what it is you're buying. Well, that's what the Senate is being asked to do here today, to grant retroactive immunity to a program where the members don't know what the program is. How does that comport with our reputation that we so pride ourselves on, the United States Senate, on being the world's greatest deliberative body? I suggest that this may be an historical embarrassment where we are voting on matters where everybody knows we don't know what we're voting on. Now, the fact may be that we vote with some frequency on matters that we don't know what we're voting on, where we have voluminous reports, impossible for any senator to go through them all. But here we're caught red-handed. Everybody knows we don't know what this program is, and yet we're granting retroactive immunity to the telephone companies. Now, I believe the telephone companies have been good citizens, and there's a way to have the telephone companies protected without giving up the program. That would be by substituting the government as a party defendant, so we could both have the program and have the telephone companies protected. Yesterday, in an extended discussion with the distinguished chairman of the Intelligence Committee and with other members on the floor, I pressed to see if anybody knew of any case which had been pending for more than 3 years, where Chief Judge Walker has handed down a lengthy opinion, running some 27 pages on the issue of state secrets on this electronic surveillance. Just a week ago today, handed down a 59-page opinion declaring the presidential power exceeding the constitutional authorization of Article 2. The first opinion is on appeal to the Court of Appeals for the Ninth Circuit. And here we are stripping the court of jurisdiction. And I pose the question, has that ever happened before? And it hasn't happened before. I intend to support the amendment. I'm a co-sponsor of the amendment by Senator Bingaman, which would follow up on what the inspectors general do to have it returned to Congress to see if the program is working. And that's a good remedial step, but doesn't go far enough. Has too many ifs, ands, and buts in it. I think it's a good fallback position, and I will support it. But I urge my colleagues not to take Senator Bingaman's amendment as a substitute for my amendment, because it doesn't go as far and it doesn't reach the constitutional issues. We are dealing here with really a matter which is of historic importance. I believe that years from now, historians will look back on this period from 9/11 to the present as the greatest expansion of executive authority in history, unchecked expansion of authority. The President disregards the National Security Act of 1947 mandating notice to the Intelligence Committee. He doesn't do it. The President takes legislation which is presented by Congress and he signs it and then issues a signing statement disagreeing with key provisions. And there's nothing Congress can do about it. And the Supreme Court of the United States has gone absent without leave on the issue, in my legal opinion. When the Detroit federal judge found the terrorist surveillance program unconstitutional, it was affirmed by the Sixth Circuit in a 2-to-1 opinion on grounds of lack of standing. And then the Supreme Court refused to review the case. But the very formidable dissenting opinion laid out all of the grounds where there was ample basis to grant standing. And now we have Chief Judge Walker again declaring the act unconstitutional, and the Congress ought to step aside and let the courts fulfill their constitutional function. It is understandable that Congress continues to support law enforcement powers because of the continuing terrorist threat. No one wants to be blamed for another 9/11. My own briefings on the telephone company's cooperation with the government have convinced me of the program's value, so that I voted for it, even though my amendment to substitute the government for the telephone companies was defeated in the Senate's February vote. Similarly, with great reluctance, I'm prepared to support it again as a last resort, even if it cannot be improved by providing for judicial review. However, since Congress has been so ineffective in providing a check and balance, I am fighting hard today again to secure passage of my amendment to keep the courts open. When the stakes are high, as they inevitably are when Congress addresses civil liberties and national securities, members frequently must choose between the lesser of two imperfect options. Unfortunately, we too often back ourselves into these corners by deferring legislation until there is a looming deadline. Perhaps this is why so many of my colleagues have resigned themselves to accepting the current bill without seeking to improve it further. Although I'm prepared to stomach this bill if I must, I'm not yet ready to concede that the debate is over. Contrary to the conventional wisdom, I do not believe it is too late to make this bill better. Perhaps the 4th of July holiday will inspire the Senate to consider its independence from the executive branch now that we have returned to Washington. These issues are extraordinarily complex. It is my hope that my colleagues will focus on these two unprecedented acts where we are called upon to vote for something we admittedly do not know what we are voting for because we do not know what this program is, and secondly, to take the unprecedented step of intervening in the judicial process on a case pending for more than 3 years in the federal courts. I thank the chair and yield the floor.
Who yields time?
Mr. President,
The senator from Vermont.
Senator Leahy has granted me.
Who yields time?
Senator Leahy is yielding time to me, has indicated that.
Senator Leahy only had 30 seconds.
Right. Mr. President, international terrorism is a serious issue, and every member of this body is pledged to protect the American people, and we will do that. But we will and must do it within the context of the Constitution of the United States and the law of the land. No individual, no president is above the law. This president, perhaps more than any other in history, has abrogated the Constitution of the United States. The time is now to stand up and say, no more. Let us defeat this legislation. Let us assure the American people that, in fact, we are a nation of laws, not individuals. Thank you.
Who yields time?
Mr. President.
The senator from New Mexico.
Mr. President, I'd ask that I'd be allowed to speak for up to 10 minutes. I don't expect to use all that time. And then my colleague from Connecticut, Senator Dodd, be allowed to speak for up to 15 minutes. That's
part of the previous order.
Mr. President, first let me just comment on the statement that Senator Specter from Pennsylvania just made about his own amendment. I support his amendment, and I want to make it very clear that the amendment I'm offering is not intended as a substitute for his amendment. I favor his amendment. I favor the amendment I'm offering as well. And, of course, I favor Senator Dodd's amendment as well, which he's going to speak about in just a few moments. So I wanted to make that clear. Let me describe the amendment very briefly. I did that yesterday, but this amendment is co-sponsored by Senators Casey, Specter, Clinton, and Senator Nelson of Florida. It's based on the simple proposition that we ought to conduct a thorough investigation before we grant any retroactive immunity to telecom companies. In my view, the structure of this bill has it backwards. As currently drafted, the legislation would grant immunity first. Then after these companies are shielded from any potential liability for their past actions, the legislation requires a comprehensive investigation regarding the company's participation in the President's warrantless surveillance program. The amendment I'm offering would fix the problem by putting in place what I believe is a more logical process. As I discussed yesterday, the amendment would do three things. First, it would stay all of the civil cases against the telecom companies as soon as the legislation is signed into law. Second, it would allow time for the inspectors general to investigate the circumstances surrounding this warrantless surveillance program. And third, it would give Congress 90 days to review the findings of that investigation before the companies could ask a court to dismiss the cases pending against them. I believe this is a very modest proposal. It would not change any of the substantive provisions in the immunity title. The amendment only modifies the timing of when these companies may seek immunity. The amendment would not prejudice or harm the telecom companies while the investigation is being conducted. All of the civil cases would be on hold. Neither side would be incurring litigation expenses. It would not create any risk whatsoever of sensitive information being leaked during the remainder of the litigation process. There would be no evidence submitted to the court during this period of stay. There would be no discovery. There would be no classified information being discussed. As I've stated, the cases would be stayed, would be on hold. Lastly, the amendment would not hamper our nation's ability to collect necessary intelligence. The amendment does not limit any of the authority being provided to the government under this legislation to conduct foreign intelligence gathering. It would not discourage telecom companies from assisting the government in the future. Under this legislation, companies would still be required to comply with lawful directives and would receive liability protection for any help that they provide. By the amendment, but the amendment does do something that I believe is very important. It would ensure that before these cases may be dismissed, Congress has an opportunity to know exactly what illegal acts, if any, it is acting to forgive. The senator from Pennsylvania made a very strong case that we don't know, the members of the Senate do not know what it is we are granting immunity for at this stage. I believe the American people expect Congress to act in an informed manner. Quite frankly, other than select members of the Intelligence and Judiciary Committees, this Congress has not been fully informed about the circumstances surrounding this program. That's precisely why the investigation that's required under the legislation is so important, and precisely why it's so important that we get the results of that investigation before we proceed. We're talking about a program that was not conducted in accordance with the law. From what we do know, may have violated the constitutional rights of innocent Americans. I hope my colleagues would agree that it is reasonable to keep these suits from being dismissed until at least we have a complete picture of what actions we are shielding from liability. Mr. President, I yield the floor and yield the balance of my time.
Mr. President.
The senator from Connecticut.
Mr. President, let me first of all, as I did last evening, begin by commending our colleague and friend from West Virginia, Senator Rockefeller, who has the unenviable task of chairing the Intelligence Committee, a very complex committee with very serious issues before it. And whatever disagreements we have should never in any way suggest a lack of appreciation for the work that he and his staff and others do to try and bring forth legislation that will allow us to balance the needs of our security as well as our rights as citizens. And it is that very question which draws me to this amendment which I've offered, which will be the subject of a vote in a few minutes in this chamber. It has been a debate now that's gone on for the last 7 months, beginning with the committee and the Judiciary Committee's reports of last fall, a debate here last December that went on, continued into January, and has gone on all winter and spring, and about to be culminated with the decisions we'll make over the next hour or so with a series of votes, including the amendment being offered by Senator Specter and Senator Bingham, both amendments of which I intend to support. The amendment that I'll be offering, along with Senator Feingold and a number of other of our colleagues here, very simply strikes Section 2 of this bill. Title 2 of this bill is the title that grants retroactive immunity to the telecom industry. The facts are very clear. The telecom industry, based on some documents, possibly a letter or others, decided that it was appropriate for them to gather up virtually all of the conversations, email, telephone conversations, and the like, of millions and millions of Americans over a period of 5 or 6 years in the wake of 9/11. As I've said repeatedly, had this gone on for months or years or a year or so, I wouldn't have raised any objection given the emotion surrounding the attack on our country. But this program, I suggest, would still be ongoing had it not been for a whistleblower that helped identify the program. This is not an issue of whether or not we disagree at all with the importance of revising the FISA legislation, the Foreign Intelligence Surveillance Act, to comply with the needs as our enemies gather more sophisticated means by which they can do us harm. It is the age-old question that has confronted this republic of ours for 232 years, and that is, how do you balance security with simultaneously protecting the rights under our Constitution? Every generation that has preceded us has wrestled with this question. The one issue we don't subscribe to is the notion that in order to be more secure, you have to give up rights. That is a fundamentally flawed idea, and every generation that has suggested it and adopted it has regretted it, in one case after another, whether it was the internment of Japanese Americans out of fear or other such cases. In every instance that we've abandoned rights for security, we have come to regret it deeply. And so this morning, I offer once again this idea: allow the judiciary to do its job. That's what they exist for. It's what the founders created, a co-equal 3 branches of government: an executive, a legislative, and a judicial branch. We're not deciding the case. We're merely saying the courts ought to do that. Retroactive immunity for companies may have broken the law, may well soon become the law. That's the danger here. And as certain as it appears that the outcome of the coming votes will be, equally certain in my view, is that this matter will not end today, regardless of what we do here. This will end up in the courts. And there, not only the wisdom of granting retroactive immunity to these companies will be questioned, but more importantly, the constitutionality of that decision. I've spoken at length here about this legislation that subjugates the role of the courts. But even as this body moves forward, Mr. President, with this bill, opponents of retroactive immunity can take some solace in knowing that it will still ultimately be the judiciary that decides the constitutionality of this action. It could hardly, as the framers intended, I can hardly see how it would have been otherwise, or how it would have passed muster with our founders. It was, after all, James Madison, Mr. President, who said, and I quote, "I believe there are more instances of the abridgment of the freedom of the people by gradual and silent encroachments of those in power than by violent and sudden usurpations." He spoke those words, Mr. President, at the Virginia Convention to ratify the United States Constitution. I can hardly see how men who did not simply utter such sentiments, but rather sacrificed everything in the name of them, could have envisioned America ceding her hard-fought liberty in a moment of fear or weakness. Is this bill constitutional? This is not for me or any one of us to decide here. I'm not a judge, none of us are. We're not a jury in this case, none of us are. We're United States senators who treasure the document that we've sworn to uphold and keep a copy, as I do every day of my life, going back to 27 years that I've served in this body. What is for this body to decide is how we best safeguard our nation's security. Greater security for our citizens is what, of course, all of us want from this bill. But if we've learned anything from this administration, it is that there is a right way to protect our nation and a wrong way. We've learned that even when those of us in this body act with even the best of intentions, we can still do lasting damage because we are not with foresight, we're not acting with foresight and prudence, but with impulsiveness and in too many cases out of fear. Mr. President, no one doubts for a moment the gravity of the threats that we face and continue to face. No one suggests that we do not have an obligation to monitor terrorist communications with the utmost of vigilance. I want to make sure that the government has every tool it needs to do so. I have no interest whatsoever in denying our government what it needs to make our country safe. I want our president to have the capabilities to stop terrorists before they act, before they inflict harm on our country, our communities, and our families. I think we can and must do that in a way that balances national security with our rights and liberties. But for reasons I've described at length in previous debates, this so-called compromise strikes no balance at all, in my view. Let us be very clear. The courts have continuously shown an ability to handle cases with sensitive security issues. Chief Judge Vaughn Walker, a Ronald Reagan appointee to the District Court, by the way, for the Northern District of California, who has overseen virtually all of the cases challenging the NSA's warrantless wiretapping program, recently demonstrated this once again. In a case against the government, Judge Walker recently ruled that, and I quote him, FISA preempts the state secrets privilege in connection with electronic surveillance for intelligence purposes. This ruling suggests that in suits against the telecommunication companies, they'll be able to defend themselves and not be hamstrung by the state secrets privilege. At the very least, this decision highlights how premature it would be for this Congress to grant retroactive immunity at this time. The sum and substance of our argument is very simply this. Now is not the time to close the courthouse doors on this issue. Mr. President, I can't say it enough. My trust remains in the courts, in cases argued openly, in judges who preside over them, and in juries of American citizens who decide them. Our courts should rather be a source of our pride, not our embarrassment. They deserve the chance to do the jobs the framers intended them to do. As complex, as diverse, as relentless as the assault on the rule of law has been, our answer to it is a simple one. Far more than any president's lawlessness, the American way of justice remains deeply rooted in our character as a people that no president can disturb. That is why even on this day, I remain full of hope and faith that we can unite security and justice because we already have over the generations. Mr. President, I harbor no illusions about what is about to happen with this legislation or its consequences. But even as this long fight draws to a close, it is worth pausing for a moment to recognize those who have joined us in writing its many chapters. They have not been written by any one hand alone. Senator Russ Feingold of Wisconsin has fought this battle with me from the very beginning. His leadership has been articulate, his commitment unwavering and unyielding. The senator from Vermont, Senator Leahy, the chairman of the Judiciary Committee, who fought valiantly to bring the Senate Judiciary Committee version of this bill that he crafted to the floor of this body. He's been a staunch opponent of retroactive immunity. The Majority Leader, Harry Reid of Nevada, has stood with us on this fight. I want to thank him for it as well. It's not been easy to be the Majority Leader, taking the position he has and also managing this bill to move forward. But even as he fought and has sought to balance his personal opposition to retroactive immunity with his responsibilities to move this legislation as leader, he has given us every opportunity to speak out against this legislation. He has worked hard to ensure the world's foremost deliberative body, as we're sometimes called, would indeed be offered the chance to deliberate over a matter that goes to the very core of who we are as a republic. In Congress's past, I cannot say with certainty that my colleagues and I would have been afforded the opportunity that the Majority Leader has given to each and every one of us, and I thank him for it. Lastly, I want to thank the thousands who joined with us in this fight around the country. Those who took to the blogs, gathered signatures, online petitions, created a movement behind the issue. Men and women, young and old, who stood up, spoke out, and gave us the strength to carry on in this fight. Not one of them had to be involved, but they chose to become involved for one reason, and one reason alone: their deep love of this country and its Constitution and its liberties. They remind us that the silent encroachment of those in power, as Madison spoke of, can in fact be heard if only we are willing to listen. All of us, my colleagues and citizens around the country, share a fundamental belief in our Constitution, Mr. President. We believe our Constitution isn't incidental to our security, but rather is its very foundation. This notion that it is the rule of law that keeps us safe should not be controversial, should not be a partisan divide. I take a back seat, as I know no one does, when it comes to protecting America's safety and security. But if history has taught us anything, it simply isn't to sacrifice our freedoms to do that. It doesn't need requiring sacrificing our freedoms to do that. I do not believe history will judge this president kindly for his contempt for the rule of law. But will history be any kinder to those of us who have served as these transgressions gathered on our watch? I have two young daughters. Their generation is going to ask their parents and grandparents some very poignant questions. Where were you when the president asked you to repudiate the Geneva Conventions and strip away the rights of habeas corpus? Where were you as a generation when stories of secret prisons and outsourced torture first began to surface and then became impossible to deny? As of today, they will ask, where were you when Congress was persuaded to shield wealthy corporations that they may have knowingly acted outside of the law to spy on our fellow citizens? Where were we in that debate? History, Mr. President, will not forget. It will not forget our role in any of this. And just as surely as subsequent generations will ask all of us those questions, what will be clear is that we'll have failed to ask ourselves one very fundamental question: does America stand for the rule of law or for the rule of men? That question never goes away. It's been the same question asked for more than 2 centuries. It has been with us, of course, these past 7 years in very strong and poignant ways. It will haunt us long after this bill passes, long after this administration recedes into history, long after all have passed into history ourselves. Indeed, generations of leaders in free societies have struggled to answer the question for thousands of years. That is the question every generation must answer for themselves. It is a battle for the American soul, waged between our better angels and our worst fears. Our founders answered the question correctly. I ask the question, will we? Mr. President, allow me to close with one of my favorite quotations, one that I've recited many times on the floor of this chamber. It is from Justice Robert Jackson's opening statement at the Nuremberg trials in 1945, in the summer, July of 1945. He said that 4 generations flushed with victory and stung with injury stayed the hand of vengeance by voluntarily submitting their captive enemies to the judgment of the rule of law. It is one of the most significant tributes that power has ever paid to reason, end of quote. Mr. President, the tribute that power owes to reason is as clear today as it was when those words were spoken more than half a century ago. That America stands for a transcendent idea, the idea that laws should rule, not men. The idea that the Constitution does not get suspended for vengeance. The idea that when this nation begins to tailor its eternal principles to the conflict of the moment, it risks walking in the footsteps of the very enemies we despise. As Margaret Thatcher said, when law ends, tyranny begins. Today, let us pay tribute that power owes to reason in this moment with these votes. I implore my colleagues to vote against retroactive immunity, against cloture, and above all, for the rule of law. And I yield the floor.
Mr. President.
The senator from West Virginia.
Mr. President, I would inquire, is there a time set for the beginning of the votes?
There is not. Approximately 30 minutes of debate remaining.
I wanted to be clear about that. This senator wanted to be clear about that, Mr. President, because Senator Bond will be coming. I will speak shortly, then he will come down to speak also. Mr. President, we're really at quite a remarkable period now because we're actually closing the debate on something which we've been discussing in this chamber, in committees, around the Congress, in the press, in general, for quite a long time. And it's been an amazing debate, and today we closed debate on the Foreign Intelligence Surveillance Act amendments of 2008. I would like to thank all of my colleagues for engaging in this critically important debate, both on and off the Senate floor, and both for and against whatever amendments we will be voting on today. People have expressed their principles, they have been articulate, they have spoken with restraint and dignity and eloquence, and I respect that very much. I think that's the essence of the senatorial behavior. We have vigorously debated the appropriate controls for electronic surveillance to collect foreign intelligence information. Since the disclosure was made 2.5 years ago about the President's warrantless surveillance program, which is a travesty, 2001 to 2007, absolute travesty. Because of the contributions, not only of those who have supported earlier versions of this legislation, but also of those who have opposed various provisions to deal with those issues, we have moved forward to craft, in this senator's judgment, a strong bipartisan, bicameral compromise that is supported not just by the Senate, but also by a House which was the House of Representatives was unwilling to support it before at all, but also by the Attorney General and the Director of National Intelligence, both of whom are entirely relevant to what is in this bill and what is to be said about what is in this bill. This final product is critical to the nation's security. I'm aware both of our rights and I'm aware of our security. That's my job as chairman of the Intelligence Committee. I have to look at both. I was brought up in a tradition and in a family which worried about rights, and I have fallen into a position where I'm in a position to see what goes on in this world and am in a post-9/11 situation. It's very, very different. It's like comparing fighting wars against the Soviets as opposed to against Al-Qaeda, Taliban, whatever it is. It's a very different world. You can't tell who anybody is. You can't tell what their intentions are. You can't tell what's in any suitcase, which may be lying anywhere in this building or anywhere else. You walk around this Capitol and you see levels of security which you've never seen ever before. We frequently evacuate this building and our offices, all because of what happened in 9/11, what had been planning well before that. But it's serious. And we all know, not that it makes any difference, it makes us no more important than any other citizen in the United States, but we do know that United Airlines 93 was headed for this building. And for this building complex. So there is an instinct to understand that what those who oppose us and who would have us change our way of life and punish us for what they see as our sins are very serious in their work, patient in their work, and willing to wait to continue their work. The final product is, therefore, critical to the nation's security, and it sets forth a legal framework to reflect the enormous changes in telecommunications technology over the last 30 years. The bill couples this improvement in foreign intelligence collection against foreign targets overseas with important protections for civil liberties, including the review by the Foreign Intelligence Surveillance Court of the targeting and minimization procedures governing these collective activities. In addition, the bill ensures that when Americans overseas are the target, that a FISA court judge, rather than the Attorney General, in a very important change, decide that there is clear authority and probable cause for intelligence agencies to target such an individual. The bill requires the Attorney General to develop guidelines to prevent prohibited activities such as reverse targeting. That was put before us by Senator Feingold, who is in opposition to this bill, but made that contribution to this bill along with others, and to ensure individual FISA court orders are obtained when required. Can't do anything these days without a FISA court review. If you're in the government, you just can't really do anything. That's only Title I of the bill, not Title II. There are new oversights and reporting requirements to Congress in this agreement, and a sunset date that means these issues will be addressed during the next administration. And I think that's very important because some people said, well, let this law be permanent and forever. And there were those of us who didn't want that to happen. Said we're in new territory here, in a post 9/11 world. It's very different, and so we need to put down into law what we believe, but we also need to go back and review that to make sure that we've done it correctly. And so, in a period of 4.5 years, by the next president, he will be able to review, along with us, what we have done and decide if we need to make any changes. I like that. I think that's fair. I think that's democratic. Certainly the most controversial aspect of this legislation has been those provisions that set standards and procedures that allow the courts to find limited immunity protection for electronic communication service providers alleged to have assisted the government in the President's warrantless surveillance program. Now, under this agreement, however, these provisions are not the blanket immunity that the administration first proposed, nor are they a statement by the Congress, either pro or con, on the legality of the program. We have debated the liability protection provisions in great depth over the past 2 days, over the past 2 years, really. As I've said, in opposition to the amendments that were offered to strike or amend the limited liability provisions, I am convinced the bill takes the right approach. We did have efforts to have substitution rather than immunity, and they were defeated. They were defeated in the Judiciary Committee. They were defeated in the floor of the United States Senate. It was thought they would be brought up again. They would have been defeated again. So we have been through this. The Senate has worked its judgment on that approach. I believe the requirement in the bill for the Inspectors General to complete a comprehensive review of the President's program is much more likely to provide the American people a complete set of facts about a program on a timely basis, to the extent that classification permits, than would continuation of the pending legislation. In other words, we've improved it. And to be quite honest, we passed 13-2 in committee, and then with 68, 69 votes, whatever it was in the Senate, we passed the Senate bill that came out of the Senate Intelligence Committee. But the House had not. They were not happy. And they had their reasons, and we went to them, the Vice Chairman, Christopher Bond, and myself, and our staffs, and we went and we worked with them endlessly. We worked with the White House to some extent, with the DNI, the Director of National Intelligence, the Attorney General's office, extensively, working through individual ways of compromising to make sure that we could protect companies that provide the intercept and the collection of communications that we need to get, but do so in a way which made it clear that they were the issue, that the government was really the issue, not them. And we have done that. Finally, with this agreement, we settle the issue of whether past or future congressional authorizations for the use of military force that do not include a reference to surveillance may be used to justify the conduct of warrantless electronic surveillance. This was an extraordinarily important thing to do, and Senator Feinstein deserves a lot of credit for that. The exclusivity amendment. We have said that you cannot conduct any of this collection outside of FISA. You have to have a warrant. You cannot go outside. You cannot use what the president likes to refer to as an inherent power to do anything he wants. You can't do that. You have to have authorization from the Congress in order to do that. That's clear for the first time in this bill. That's huge. That restricts some of the comments that we've been hearing earlier. So FISA remains the exclusive means by which electronic surveillance or interception will be conducted from this point forward, unless the Congress sees some reason to make it either stronger or whatever. With enactment of this bill, there will be no question that Congress intends that not only express statutory authorization for electronic surveillance or interception may constitute an additional exclusive means for that surveillance or interception. In other words, you just can't do anything more without congressional authorization. That's oversight. That's what we ought to be doing. It's what we should have done. What we didn't do. The world changed. We didn't change quickly enough. But we have changed enormously in this bill. This is buttressed further with the clarification that criminal and civil penalties can be imposed for any electronic surveillance that is not conducted in accordance with FISA or specifically listed provisions of Title 18. In closing, I would like to address my colleagues who would have preferred a different result than the agreement before us today. I would urge them, not so much now, there being not much time, but I would urge them in the coming days and weeks, months, to look at this legislation in its entirety. Not to think about a single point here or a single point there, but to look at the whole texture of it. Because this is what we're doing. That's why we have a sunset date, so that we will again be looking at it. So looking at the larger picture, seeing what the balance really is, and are we keeping it properly, is between safety and civil rights, individual rights, is very, very important. This is a bill that provides a framework and stability within the Foreign Intelligence Surveillance Act for a collection system that will work well for national security. That's very important to this nation. That's very important to this body and to every single American. This bill, Mr. President, is vastly better than the Protect America Act, obviously enacted last August, and much preferred to any additional short-term extension of that flawed statute, which was one approach. This is a bill that contains important safeguards for civil liberties and effective mechanisms for oversight. I don't think any of the committees that deal with these matters will ever be the same again, nor have they been in the last year and a half with respect to oversight. The vigor, the passion which we sought, leveraged, coerced in some cases, the administration to make more people read into the program, to make more people a part of the discussion, to make more people a part of of the knowledge, which they held so closely to themselves, almost as if taking it. I mean, I remember at one point I was one of 4 out of 535 people who was briefed on the program, and they kept saying on television, the Congress is briefed. And this was a joke. This was a farce. I won't go into it further, but just believe me, it was. They did not do that. They did not want to do that. That is their nature. And now it's different. Now we're all over them. And we have a lot more to do before this Congress gets out with respect to the oversight factor of Congress, which is so important to us and to the nation. So support for the agreement says to the intelligence professionals who will implement the new authority that Congress takes seriously its oversight responsibilities. Some of them don't like that fact. They don't want us to. They want to be able to do what they've always done because they could do what they always wanted to do before the world changed. And now they can. Yes, we've had intelligence committees for a long time, and yes, they've done work for a long time, but there's never been a greater need for tough oversight. Sometimes when the director of the CIA calls me, and I don't think I'm saying anything privileged here, and he wants to tell me about something good that's happened. It's a secure conversation on a secure phone. And I said, look, when I hear from you, I want to hear what you want to tell me that's good. I also want to hear from you something which is not working right. And so that's the pattern that's developing. They're a little more timid about coming up to us. We have to negotiate more to have them come before us. But we do it because we need them, and they need our oversight. They are not free to do entirely what they want to do, but we have to give them the full right to keep us safe and yet balance, as we do, I believe, in this bill, civil liberty protections. So I just simply close, Mr. President, by congratulating all people involved. I think for a subject which was meant to be understood by so few in this body, many, many, many people have expressed views on the floor, to many of us in private. It's been the subject of caucus discussions. It's a major, major piece of legislation. And I urge my colleagues to oppose the 3 remaining amendments. And I urge my colleagues to vote yes on final passage. They will serve their nation well. I yield the floor.
Mr. President.
The senator from Florida.
Mr. President, is there an order established here under unanimous consent?
There are 3 minutes remaining for the senator from Wisconsin, Mr. Feingold. And 9 minutes for the senator from Missouri, Mr. Bond.
Would the senator allow me to have a couple of moments? Well, since what's the parliamentary procedure since Senator Feingold is not here? Is that locked in just for him?
He has
Oh, he has. Okay, then I would just ask consent. Since there's not any time left, I would ask consent that I be able to put a statement in the record at this point in the record.
Without objection?
Mr. President.
Mr. President, may I just inquire whether that is entirely necessary, or rather the parliamentarian, is that entirely necessary? I mean, the senator does wish to speak. We aren't starting votes quite yet. There doesn't seem to be a total limit on that, a time set for that. And the senator has been wanting to speak for a number of days. And I would be happy if he would be able to do that.
There are only 3 minutes left on the majority side for Senator Feingold.
What about leader's time?
Only the leader has leader time.
And that is correct.
Mr. President.
The senator from Washington.
Mr. President, I rise to speak on this issue, and I did just get time from Senator Feingold, so if there is a minute or two left, I'm happy to yield whatever time to the senator from Florida. But like him, I come to the floor wanting to speak on this important issue. I know that we've had many discussions about it, and many people have been focusing on it. But I think it's very important that we consider this legislation in the most serious fashion that I know my colleagues are doing, but to think about the long-term consequences. While proponents of the bill claim that it has been designed to monitor foreign-to-foreign communications that pass through the United States without a warrant, I believe the bill actually goes much further, providing a broad expansion of authority to conduct domestic surveillance. That's what many of my colleagues are trying to discuss here, that we're talking about spying on U.S. citizens. And we want to protect our country's national security, and we want to also protect Americans and make sure that there is accountability of checks and balances that our founding fathers thought through in the Constitution. I recognize that some of the changes have made to this bill some people see as vast improvements. I think that they are changes that can somewhat be cosmetic but don't go to the privacy rights of protecting Americans. The administration wants to make sure that no court has the opportunity to review the potential illegal activity that's part of this bill, and that's of great concern to me. The bill permits the government to collect all Americans' international communications, even communications of innocent Americans with no connection to terrorism or national security concerns. This bulk collection of innocent Americans' private communication is unacceptable and contrary to Americans' values and the fundamentals of our constitutional protection. While the administration has ignored the congressional mandate that the Foreign Intelligence Surveillance Act is the exclusive means for conducting wiretapping activities on American citizens, Congress cannot ignore the weighty constitutional issues being decided here today. Just last week, the Federal District Court, Judge Walker, rejected the administration's claim that the President's constitutional authority trumps the FISA law. Basically, they were saying, in effect, that they cannot use the certain provisions of the to stop the legality of surveillance of having these issues in our court cases. I'm also troubled that the telecom companies will not be held accountable for participation in the Bush administration's warrantless surveillance programs. Congress should not be providing blanket immunity for telecommunication companies that cooperate with the administration's warrantless wiretap programs. The bill effectively grants the retroactive immunity to these companies, and I think it's very important that we understand the judicial process that is taking place here.
Senator's time has expired.
I thank the President.
Mr. President, how much time I have left?
9 minutes.
I yield a minute and a half to my distinguished colleague from Florida.
Well, I am grateful to the Vice Chairman, and I just want to say, and I will do it in a minute and a half, how much I appreciate the Chairman and the Vice Chairman being able to come up with a product that we need so that we get some certainty about the court review of this process so that we can balance this interest of going after the terrorist, but at the same time protecting the civil liberties of American citizens and American persons that are here legally in the country. And I think the bill does that, and we've struggled with it for a year and a half in our committee. And I'm certainly going to support the final product. Now, there are obviously, Mr. President, some matters that we've had in the Intelligence Committee that we are not able to discuss here, and I'm sure that the people listening understand that. I just want to say on the controversial issue of immunity, I don't believe in blanket immunity for the phone companies, and that's why when this issue was in front of our Intelligence Committee, I offered language to deny them immunity, but it failed, my amendment, and it failed miserably. And so when it came to the floor, I offered a compromise to the full Senate, along with Senator Feinstein, that would have required a special court to review the phone company's action. But that failed as well. And my final sentence, Mr. President, now I'm backing an amendment by Senator Bingaman that would at least delay immunity until an investigation is complete, and that'll allow us time to change some minds if the real wrongdoing is found. Thank you, Mr. President.
The senator from Missouri.
I thank the distinguished senator from Florida who has been a hardworking member of the Intelligence Committee and really has been a great contributor. I'm sorry he does not agree with the compromise we reached with the House to have the district courts make a review. I think that is important. That satisfies the needs. Several points have been made on the floor today and previously need to be answered. It's been said that the new surveillance powers allow government to collect all communications between U.S. and the rest of the world, millions and millions of communications between innocent Americans, parents calling children abroad or people serving in Iraq, no prohibition on reverse targeting. Well, as the senator from Utah said earlier today, unless you have al-Qaeda on your speed dial, you're not going to be collected against. A plain reading of the bill shows us that this statement is simply inaccurate. There are safeguards in place to ensure that any conversations that do not have foreign intelligence information will not be kept or shared. They will be minimized or suppressed. Americans either inside or outside the United States may not be targeted without a court order. The outside of the United States protection was something that we added on a bipartisan basis in the Senate Intelligence Committee. And the FISA court, in addition to approving any collection against an American or anybody in the United States or an American overseas, will have to be proved. But the FISA court will review all procedures used to target foreign communications and make sure that communications with innocent Americans are minimized or suppressed. As far as reverse targeting goes, I refer my colleagues to Section 702B of the bill, which says an acquisition authorized under subsection A may not intentionally target a person reasonably believed to be located outside the United States if the purpose of such acquisition is to target a particular known person reasonably believed to be in the United States. And I can assure you that I and other members of the Intelligence Committee have reviewed the procedures, have seen the operations, know the supervision, and know the very tight constraints under which these professionals operate. They're overseen by supervisors, by higher-level authorities, by inspector general, by lawyers, their own lawyers, and lawyers from the Department of Justice. And somebody made an error and collected some criminal information a year or so ago, and that was dealt with appropriately. There is no ability for somebody, even a rogue who happens to get in there, to get away with targeting innocent American communications. Now, there's been a lot of debate also about the senators having access to all of the information. As I pointed out earlier, we set up the Senate Select Committee on Intelligence to provide the most highly classified information to members of the committee. And I have worked hard with the chairman, and we have opened up to the full Intelligence Committee far more information than we ever got before, because I believe the Intelligence Committee has a heavy responsibility to make sure that what is being done stays within the law, stays within the guidelines, and protects the rights of American citizens. But if you say that every intelligence matter should be briefed to the entire Congress, where does that stop? Should we then brief the New York Times directly so they can publish a story and decide whether or not intelligence activity is acceptable? I think not. I think we've seen the problems that occur when leaks have compromised our intelligence. They've done it too often. Some people still want to debate the legality of the TSP, saying it's blatantly illegal. Well, they persist in their belief that the President lacks the constitutional authority to conduct warrantless foreign intelligence surveillance, even though Article 2 has not changed in over 200 years. The FISA court itself, en banc, in re seal case, has noted the President has that authority, and Congress, if it tried to pass a law saying that the President doesn't have that authority, it would be found to be unlawful. The intelligence community has been overseen by the Intelligence Committee, and we have found clearly that the companies acted in good faith. Regardless, however, of the legality of the President's TSP, it's a matter of fundamental fairness. These providers should not be punished by forcing them to litigate frivolous claims or by delaying this much-needed relief. Without these companies, without their active participation on this and many other matters, the intelligence community is fearful and has lost cooperation in the past. They are taking risks by being good, patriotic Americans. And there are some who want to punish them. They want to kick them to get at the administration. Well, this bill does not prohibit lawsuits against the government or government officials. And I believe that the time has come for us to pass a bill after 15 months. We now know that we have before us ability to give clear, authoritative directions and guidelines to the intelligence community to operate, to keep us safe. We've added new protections. And if the President had not followed the advice of the Gang of Eight and had tried to reform the FISA rather than using Article 2, we wouldn't be just debating September 11th. There would be many others. I would urge my colleagues to vote down all of these amendments and pass this badly needed modernization of the intelligence collection through electronic surveillance and the provision of additional privacy rights and protections for American citizens. I thank the chair and I yield the floor.
There will now be 2 minutes of debate, equally divided, prior to a vote on the amendment offered by the senator from Connecticut, Mr. Dodd.
Mr. President.
The senator from West Virginia.
May I ask, please, that all time, I guess, has been yielded back, that en bloc, that the Vice Chairman and I ask for the yeas and the nays on all of the upcoming votes.
Objection. The yeas and nays may be requested on all three amendments. Is there a sufficient second? There appears to be a sufficient second.
Mr. President.
The senator from Connecticut.
Mr. President, this is the 2 minutes equally divided. Is that the moment we're in here at this moment?
The senator is correct.
Well, Mr. President, this has been a long debate. It started last fall. Again, let me commend the two members here, chair and ranking member of the committee. I respect their efforts. But my friend from Missouri has made my case. This is a matter for the courts to decide, not for the legislative branch to decide. It's why we have three co-equal branches of government. It's not our business as a jury or a judge to determine the legality of what occurred here. This much we do know through published reports. Since 1978, 18,748 requests for warrants from the FISA courts have been granted. 5 have been rejected. Why did this administration not proceed with the normal course of events here and seek justification and legal authority for the vacuuming up of private information of American citizens? All of us here want our agencies to do everything they can to protect our security. But all of us equally care about the liberties of our country. The false dichotomy that is being suggested by what is in this bill, that in order to be more secure we have to give up rights, is a dangerous dichotomy. It is a false choice. Previous generations have made it. We should not. Let us strike this title, allow the courts to determine whether or not what occurred was legal or not, and then proceed forward. Some of the companies did not do what others did because they felt it was not legal, what they were being asked to perform. There clearly was some doubt in the minds of people as to the justification of this. And so I happen to believe that the best way to proceed, as Judge Walker, appointed by Ronald Reagan of the District Court, which has handled most of these NSA cases in the past, that the privilege, the secrets privilege, will be protected. Courts can do their job and determine the legality here. It's not the place for the United States Senate to act as the judicial branch of government. That's why the founders created 3 co-equal branches of government. That's what the issue is here, the rule of law or the rule of men. And that's what this amendment does by striking this title and allow these matters to go before the courts. And I urge the adoption of the amendment.
Senator from
Permit me to relieve the senator from Connecticut, a good friend and a good legislator, of some of his concerns. Number one, during the president's terrorist surveillance program, even though he was operating under Article 2, he went to the FISA court to get warrants for listening in on American communications. The same procedure that we have outlined in this bill today. What he was able to do was to listen in on terrorists reasonably believed to be abroad, which is now included in our bill. Article 2 is clear that he has that right. Article 2 was used by President Bill Clinton for a physical search of Alder James' home. And the Congress responded by giving him more power. Secondly, it said that Article 2 is not should be challenged. I point out that there is no ban on lawsuits such as a lawsuit before Judge Walker on lawsuits going forward against the government or government officials. The Intelligence Committee conducted a comprehensive review of the TSP. We determined on a strong bipartisan basis that the providers acted in good faith pursuant to representations from the highest level of the government that the TSP was lawful. It is not right to punish patriotic Americans who step forward and help their government by subjecting them to the harassment of lawsuits. I urge the defeat of the amendment.